Welcome back. So you heard then the trending topics. One of the trends is about next year's election, and our interview now speaks to that as well. Yesterday, the Constitutional Court heard arguments from the legal representatives of the President, Parliament, the Department of Home Affairs, as well as the Independent Candidates Association in the Electoral Amendment Act matter. Now, the new Electoral Amendment Act, which was passed into law in February this year, against concerns, of course, that were raised by civil society organizations and interested parties. Now, these entities argue that the Act actually poses a burdensome barrier of entry for independent candidates who would like to contest the elections and stand for public office in the country next year. Now, arguments at the Constitutional Court will resume today, but just to take a look at yesterday's developments, we're joined by Dr. Michael Louis. He's the chairman of the Independent Candidates Association, and they are, of course, an applicant to the Concourt. Dr. Louis, good to speak to you again. Welcome to Morning Live once more.
Good morning, Zakina, and good morning to the viewers.
So from your perspective, if you will, please indulge us by giving us a quick synopsis of what happened yesterday and how you see your chances in terms of the arguments that were made.
Well, I think the big thing is, Zakina, I think firstly, a person's so grateful that a person's got a separation of powers, being the judiciary, the legislative, and the executive. And once again, it played out yesterday because I think the ICA and OSA made excellent cases about the unfair barriers to entry, and that I think there is constitutional agreement that there's unfairness and unconstitutionality. I think that's how I perceived it. But I think where the courts are grappling with is the whole issue of the separation of powers and how far can the courts go to intervene with a mandate that was given to Parliament to actually draft an electoral act. And because of the time constraints, and the IEC and the minister is really pushing for an order so that we can go on with the electoral elections next year, I think that's where the tire hits the tar, and we're going to resume today. But I must say that the judges really knew their work. They read their papers. I felt so good, and my team did an excellent job. And I really believe we're in with a chance.
Some of the country's top legal minds, of course, arguing for and against what their respective clients want them to do. But some of the arguments, as you point out, were regarding biases against independent candidates, such as the number of signatures required, also the recalculation on vacancies when an independent candidate drops out of the race for whatever reason. So if you will, just for the benefit of our viewers this morning, Dr. Louis, just talk to us about some of those arguments.
Well, I think there's three arguments that are very clear in front of the court. I think ICA, the Independent Candidates Association, argument is really very clear-cut, and we try to be as streamlined as possible because it's not only about your case, it's about the remedy that you're asking the court to do. So we're saying, and Justice Rosen really got it very well, is that we're saying it takes 43,000 votes for a political party to get a seat in office. But it takes more than 88,000 or 90,000 votes to get an independent candidate into office, which means an independent candidate must get twice the numbers, which obviously is totally unfair and unconstitutional. The OSA case is about barriers to entry with signatures. In the past 30 years of our dispensation, every single political party had to get 1,000 votes, 1,000 signatures to get into office. And now Parliament has raised it in more than 1,008% to anything from 10,000 signatures to 15,000 signatures, which is just absolutely an impossibility. And I think I've said it before on your program, if an independent candidate or a new political party has to get 10 to 14,000 signatures, they have to employ 6 people for 6 months working 8 hours a day just to get those signatures, and there isn't time. So we're asking the courts in both issues for a writing-in clause because we don't want it to go back to Parliament. We're asking Parliament for the ICA case, to divide the 400 seats in Parliament to 350 to 50 proportional, because that will allow independent candidates and political parties each to get around about 45,000 votes to achieve a seat. And that complies with the constitutional provision of everybody is treated equal in front of the law. And then obviously with the OSA case, we're asking the courts to rule that 1,000 signatures are compliant to qualify as a small party or an independent candidate, because that's what there was for the last 30 years. And we did a very good comparison in Kenya, in Canada, Turkey, that have got the same political dispensation as what South Africa's got. And all of them, they need 25 signatures, 100 signatures, but nothing like the 14,000 that is expected. And I think the judges understood that.
So some of it, Dr. Louis, on the face of it, seems pretty straightforward. If you're saying that it's 43,000 votes for parties, it should be the same for independent candidates. Similarly, with the signatures, if you're saying 1,000, it should be 1,000 across the board. However, if we could just break down and perhaps explain a little more acutely the issue of proportionality, because at the moment, the split in the National Assembly is 50-50, so 200-200. And you mentioned it now. You're saying that should actually be 350-50 for proportional representation. So just explain that to, our viewers who are watching right now, who are not necessarily in the political space, what that would actually mean.
Well, look, firstly, just to say, I think even some political authors and academics are struggling with all the maths and the term in general proportionality. But what has actually happened is when Parliament made 400 seats of Parliament available, 200, the 200 extra seats are the component that will generate proportionality. That is what will balance it out to make the Constitution compliant. And that has always worked for 30 years. But what has happened now is, and that's what happened yesterday because of our actuarial submissions and Michael Atkins' report, we showed that even at 350 direct seats and 50 proportional, we still tick the box for in general proportionality. And so you don't need to have 200. You can have 350-50, because that 50 additional balancing act still generates in general proportionality. And in all the papers, both the respondents and their experts have agreed with us that we've ticked the boxes of in general proportionality when it comes to 350-50 as well. So I think that was a big step in their submission and their concession.
Dr. Louis, when all is said and done, all the technicalities and, the Constitutional Court arguments aside, it comes down to a question of time, because will there be sufficient time for what you are pleading with the court, to hear and recognize and hopefully have that written into law before the elections? Is there going to be sufficient time for all of that to happen? And also, if it doesn't happen, how does that then impact the election, and how does it prejudice those who were hoping to stand as independent candidates?
Well, Sakina, we've always wanted, as the IC and OSA, to be a constructive force, and that's why we streamlined our cases and our remedies in such a way that there's no disruption to the election. And I think in the papers, both the respondents and ourselves are aware of it, and that's why we're all pleading the court to come with an order before the end of September. So what we've asked is a very difficult thing, and that's also what the courts are grappling with, is what we call a writing-in clause, is that the courts actually write into the Act our amended changes. So, for instance, where there stands 200 proportional and 200 direct, there's now going to stand 350 direct and 50 proportional. It's just a striking in. And when it comes to the signatures, where it talks about 15% of the quotas in the region, it's just going to say that the signature requirement will be 1,000 signatures across the board. So we believe that there must be a respect for separation of powers, and we believe that once the Concourt has done their judgment, that the Parliament will then have the mandate to go and do an amendment to the Act and rectify, which I think could even be done before the end of the year. So that's our heart, that's what we're expecting, that's what we're pushing. And so as a result, I definitely think the viewers can be comfortable that there's no chances that this action will delay the elections in any way.
So just to that final point, Dr. Louis, the separation of powers, when you're asking for a writing-in clause, does that not compromise the separation of powers, where we are now asking the courts to actually basically, in some way, infringe on what Parliament was supposed to do?
Zakina, I asked you to be nice to me this interview and not ask me these difficult questions. I'm just joking. I think that's where the courts are grappling with, and I think it's something that is what the courts don't really want to do. But very good precedent and very good cases were brought and presented by our legal teams, and precedents where the courts have done it. They definitely have got the mandate to do it. They've definitely got the willingness to do it, and I believe they will do it. So that's where I stand on that issue.
Well, we're going to leave it there because those arguments continue today in the Constitutional Court. But thanks so much for your time, Dr. Michael Louis, Chairman of the Independent Candidates Association. And they are, of course, an applicant to the Constitutional Court in this case. Dr. Louis was discussing yesterday's proceedings at the Constitutional Court in the Electoral Act hearing. The court adjourned and proceedings will resume today. Let us know your thoughts at Morning Live SABC.